You're listening to the American Democracy Minute, keeping your government by and for the people. A November 20th federal appeals court decision ruled that only the U.S. Attorney General can bring a voting rights lawsuit under the Voting Rights Act. The decision, a radical departure from settled law, erects barriers to minority voters seeking fairness in federal court. The 8th Circuit Federal Court of Appeals voted 2-1 to dismiss an Arkansas racial gerrymandering case, which diluted the voting power of black Arkansas voters, saying there was no private right of action for voters, groups of voters, or advocacy groups in challenges under Section 2 of the 1965 Voting Rights Act. Democracy Docket reports that the ruling applies to states covered by the 8th Circuit: Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. A ruling in the 5th Circuit earlier in November came to the opposite conclusion and acknowledged the right of voters and groups to sue. According to a filing in the Arkansas case, in the past 40 years there have been at least 182 successful VRA Section 2 cases. Of those cases, only 15 were brought solely by the U.S. Attorney General. The U.S. Supreme Court's Milligan case earlier this year was brought by voters and advocacy groups, suggesting that the 8th Circuit went rogue in its decision. But in the meantime, it may affect fair maps and proper representation for millions of minority voters. We have links to the ruling and analysis at AmericanDemocracyMinute.org. I'm Brian Veal.